Webinar started. Hello, everybody. My name is Shirley Liu. I'm with the Asian Pacific Institute on Gender-Based Violence, and I'm going to be moderating and facilitating this webinar for you today. I am joined by two amazing speakers, Bill Tamayo and Linda Lee from the EEOC San Francisco. A couple of just introductions and things like that before I turn it over to the presenters. This meeting will be recorded, or this webinar will be recorded, and it will be available later on our website, along with the slides and any resources that the panelists are sharing today. So I'll send that to you in a follow-up email, maybe about a week from today. We do have live captioning happening. So if you want to find that, it's at the bottom of your screen in your little tool bar at the far right, or if you click the little option arrow for more options, you should see something that says CC, and you can click that and choose the options for size and how the captions appear. Let me know in the chat box if you have any issues accessing the captions. Throughout the webinar, please feel free to share any questions that you have, any reflections, any comments, any resources and things like that in the chat box. And the presenters will do their best to address those questions towards the end of the webinar. So just to introduce myself, or my agency, the Asian Pacific Institute on Gender-Based Violence, we are a national resource center providing technical assistance, training, resources, policy advocacy, and other forms of engagement on issues affecting Asians and Pacific Islanders in the United States and territories, so including domestic violence, sexual assault, sexual harassment, human trafficking, many issues affecting Asians and Pacific Islanders. And we do training and technical assistance. So also feel free to get in touch with me if you want to, request a training or anything like that. I'm going to briefly introduce our presenters before I pass it on to them to introduce themselves more fully. We have Bill Tamayo and Linda Lee. They are from the EEOC, the Equal Employment Opportunity Commission in San Francisco District. Bill is the district director and Linda is the outreach and education coordinator, both at the San Francisco District. And we have worked with them in the past to do various trainings and presentations before, and we're very excited to be bringing them here to do this session for you all. So go ahead and take the mic.
All right, thank you so much, Shirley, and thank you very much to the API Institute for inviting us to present this morning or this afternoon, and good morning and good afternoon to everybody. I want to really thank the Institute for setting this up and thank all of you for your work. These are some very trying times for Asian Pacific Americans, and also in the area of sexual harassment and sexual assault. It's been a very difficult time, so I just want to thank you for your work. Our whole purpose today is really to provide you a working knowledge of how to deal with people who are sexually assaulted or sexually harassed at work. So my experience is I'm the district director for the EEOC, meaning I kind of oversee all the investigations and operations for the EEOC. But for 20 years before I got to this job, from 95 to 2015, I was the regional attorney directing the litigation. So I oversaw a lot of sexual harassment cases that we were litigating in federal court. And then before I joined the EEOC, I actually was a staff attorney and managing attorney at the Asian Law Caucus in San Francisco. And one of the major projects I had done was working on the cases that were referred to me from the Asian Women's Shelter of women who were battered and who had immigration issues. And so I represented them before the Immigration Service. And this allowed me to work on developing the VAWA self-petitioning provisions that allow battered women to file their own immigration visa petitions. So, Linda?
Yeah, I was hired by Bill at my first job at the Asian Law Caucus doing outreach to the community. And after an intervening job, I followed him back to the EEOC. It's great to be in partnership with somebody who really gets the community. And I like to think of my job as being the person to make our laws and process accessible to a wide variety of audiences, right? So it's a great pleasure to be here with you today. Thank you for tuning in and hopefully gathering information that you can bring back to your community.
Okay. You want to just start rolling, Linda?
Sure.
Excellent. So if anything you can remember from this training, it's workers have a right to be free from discrimination and harassment. The people in these photos are people we'll talk about. They're all represented by the EEOC in some capacity, and we're going to talk about their cases. Next slide. And then our services are free. The individual in the top person is a farm worker, Olivia Tamayo, who we had litigated a rape case. She was a farm worker near Fresno, California. Next slide. And then, so important to point out here is who is covered by these laws, federal laws. So anybody who's an employee in the United States or its territories, and she works for a company that has 15 or more employees, she's covered by federal law. Some state laws have lower number thresholds of required a number of employees. So for example, in California, if it's sexual harassment, she needs to only be one employee, so she's covered. But generally it covers employees, temporary workers, people who apply for jobs. So for example, that can be somebody says, well, I applied for this job, and this guy said, if I wanted to have a job, I had to have sex with him, and then he didn't hire me because I refused. Well, she's protected by the law, even though she didn't actually work. It includes a former employee. So a former employee could be applying for a job and says, well, I like to apply for this job. And then her previous employer tells the new employer, well, you know, she complained about sexual harassment. I wouldn't hire her. She might have a case against the previous employer because he's retaliating against her and saying something about her. Then undocumented workers are covered also. I will get into that a lot more at the latter part of the program. But so virtually almost every worker is protected so long the employer has 15 or more employees. Next line.
Oh, sorry.
And so the important thing here is the laws against discrimination are still a relatively new part of US history. They didn't become law until 1965 after the passage of the Civil Rights Act of 1964. The main law we're going to be talking about today is called Title VII of the Civil Rights Act. So it covers all forms of terms and conditions of employment, any kind of discrimination on the basis of race, color, sex, national origin, or religion. And it also prohibits retaliation. So a critical point here is sexual harassment wasn't even recognized by the Supreme Court until 1986 as a form of sex discrimination. So why I put this historical slide in here is I want you to appreciate that for most of this country's history, it was legal to discriminate on the basis of sex, make sex a requirement for a job, even fire a woman if she refused to have sex in order to keep her job. There was virtually no federal law that protected. And then we also enforce the laws against disability discrimination, against your genetic information being taken or being used, and also the laws against pregnancy discrimination and age discrimination. All right, let's take it away. Yeah.
Do you want to just mention the Supreme Court? Oh, I'm getting really bad.
Yeah, and also, I mean, and let me just talk to you about. The problem is I can't see the rest of the slide. But anyway, we also, so part of sex discrimination, as the Supreme Court recently ruled, covers discrimination on the basis of LGBTQ status. This was an important case, the Bostock case that the Supreme Court ruled on. It took on 3 different cases. And one of the other cases was a case involving a transgender individual out of Michigan, where we litigated a case on her behalf. And the Supreme Court ultimately ruled that gender identity was also a protected category. Okay. Go ahead, Linda.
So we're providing a brief overview of what we do, and our main focus today is going to be talking about harassment, but we thought we would make sure that you're clear on all the ways that EEOC protects you, right? So we're probably used to thinking about discrimination as being treated differently, right? Because we belong to one of those protected characteristics that Bill mentioned earlier. And let's point out that we can be protected under an intersection of those characteristics as well. So we're used to maybe that as our definition for discrimination, but we also wanted to point out that our laws also offer that people need to be offered an accommodation on behalf if for the reasons of disability and religion. And I have here one of my favorite images that talks about how fairness and equity sometimes results from not necessarily treating everybody the same way. You want to make sure that they have equal opportunity. So that's the idea behind this cartoon, right? If you give everybody the same size box, that's not necessarily going to give them that equal access that we're talking about, the equal ability to work. So just briefly, we're going to focus on harassment in just a second. We wanted to give you some illustrations of what we're talking about. Here, I'm referencing a class case we brought against Abercrombie and Fitch, where we alleged that African Americans, Latinos, and women were discriminated against, were not given equal opportunity, especially for front of the house positions. And so in 2005, we obtained a $40 million settlement against Abercrombie and Fitch, on behalf of Black, Latino, and Asian employees, as well as females. So that is one example of being treated differently. Again, going back to that notion of accommodation, we said for disability and religion, an employer must accommodate unless there's an undue hardship or undue burden. I'm also going to reference another case we had involving teens. Here are 3 teens who were denied work at Abercrombie and Fitch for, again, not having that all-American look, but here it's because they were wearing the hijab. One of these cases actually went to the Supreme Court, and ultimately we say the employer must accommodate the hijab absent undue hardship, right? And you cannot argue, well, our customers would have been offended. That's not a justification for this type of discrimination. But moving forward, here's a harassment.
Okay.
Bill?
Okay. Okay. Thank you. So these are facts from an actual case that we litigated out of Oregon. So what's your role here? Young worker comes to you and she describes that, you know, her supervisor is a male in his 50s. He started off in a professional way, and then she trusted him, but then he started with these awkward hugs, which gradually led to more and more touching. And then she notices that he's doing this to another coworker. There's hugs, standing behind her and pressing his body into hers. She says, when I mentioned this to some coworkers, they said, well, that's just how he is. So what questions would you want to ask? And what advice would you give if this employee came to you?
So we're going to encourage you to go ahead and answer in the chat if you'd like. How would you respond in a situation like this? And another question maybe as you're thinking about this is, what is it that keeps people from reporting harassment? So I see in the chat, have you told him to stop?
Good.
Any other questions? How is this affecting you? Responding to the emotion in the situation? Does it make you feel uncomfortable? Any other responses? I think these are great questions. These are the questions that we wanted you to help you answer as we move forward. If you leave this workshop, we're hoping you come up with some good answers to this. And I want to say that have you told him to stop is a good, I think, a natural response. One thing we want to filter our responses to is is there a possibility that people, that the person would hear that question in a judging way, right? Where you put the onus on the worker. So I don't think that would be the intention, but it would be good if we can kind of examine our reactions and make sure it doesn't feel like we're putting a judgment or the onus for stopping on the person who's telling us their story, right? We want to make sure we don't come across as judgmental.
Next one, next slide.
Okay.
So I've done versions of this training, and I developed the training particularly aimed at staff who work at domestic violence programs, sexual assault programs. And partly, and why I realize this, is that many of these programs have been using or addressing sexual assault, but not in the workplace. And so, but I want to use the same language, because what we hear, and I've often heard this, I've done this training, countless times to SA and DV programs, and there's always somebody who says, I wish I knew about these laws 2 years ago, because this woman came to our program and she told me she was assaulted at work and I didn't know what to do, right? So this is the important thing for this whole program, because we look at DVSA programs as the front line that the work that employees may go to if they've been assaulted. They may not go to their family. They may not go to HR, human resources. They may go to you. So how we look at it, traditionally, right, it's violence and control is what really allows sexual assault to happen. It's the perpetrator having all this control over the victim survivor. And we always talk about that imbalance of power. But having done DV cases in the immigration context and then moving to the EEOC, I've felt to a certain extent the control and the imbalance of power is the greatest in the workplace, because there the employer has all these other, or the harasser has all these weapons at his disposal, right? He has the company, he has the company's lawyers, he has the company's money. He can determine whether Maria's going to eat or not, whether she's going to have a room over her head, all of these things, because he controls really controls the economic situation for her. And so what we try to do is look at the sexual violence. It's a part of sexual harassment. And then in harassment at work, what our job, unlike in the other settings where we want to get the perpetrator perhaps arrested, convicted, we want we move the batterer or we move the people who have been battered away from the batterer, put her in a safe place. Those are all important things to do. But in the workplace, what we're trying to do is make the workplace safer by holding the employer responsible. And that includes also paying the worker with money for damages and for compensatory damages, pain and suffering, in order to make her whole. And also to give her money if she lost her job, if she was fired in retaliation, if her hours were cut, or if she was demoted. We want to make sure that she gets that money back. Unfortunately, because reputations are at stake, there's in these cases, and the companies have a lot of money, they do everything to destroy the claimant's credibility. They'll try to get the case dismissed. They'll offer her low money with very low and make sure that it's confidential. You've seen this in the whole Me Too movement cases, but in the workplace, this stuff gets exacerbated. And for teen workers and immigrant workers in particular, the imbalance of power is even greater. It's accentuated even more because they don't know their rights, they're scared, they don't think people are going to believe them. So this is what's going on, and then you play the critical role as either counselors, co-workers, what have you, to hear her story so that she can make her claim go forward. Linda, move to you.
Sure. So again, responding to what I'm seeing in the chat, I think people, as Bill mentioned, acknowledge when this kind of when harassment takes place in the workplace, there's something else at stake, right? This is how somebody's making a living, is earning money. And so people fear reporting because that's what's at stake, your ability, to earn money, make a living. And that often keeps people quiet. And in addition to that, if you're a vulnerable worker, like a teen worker, right, the power imbalance is even greater. I'm going to go back to the scenario we had started putting out there, where you had the older male restaurant manager who repeatedly targeted and groomed the female employees. In this case, out of Oregon, he targeted female wait staff ages 15 to 20 with sexual comments and inappropriate touching. Also, let's point out this manager was the night shift manager. And because he spoke both English and Chinese, this is a Chinese restaurant, he was relied on as the person who kind of like could speak to everybody, right? The owner didn't speak that much English. And so he had additional power because he was the translator manager. And so what happened is he actually had asked one of the 15-year-old employees to text him nude pictures of himself. And as a result of this, her parents called the police. He got arrested at work for sexual abuse of a minor. And yet, even though the arrest took place at work, and so it was very much, public, the owners allowed him to continue working there. In this case, we alleged sexual harassment and retaliation, and we obtained a settlement of $120,000 and sweeping workplace reforms. But I also bring up this story to tell you, to kind of point out, what are the factors that increase the likelihood of harassment? EEOC did a study. The link is on the web page, or sorry, on the screen in front of you. But we look at the elements that make it more likely that there's going to be harassment in the workplace. And we see definitely one of the key factors we have identified is in workforces where there are many young workers, because often these people don't know what their rights are, don't know how to respond. And so that's, again, a key reason we're excited to do this training with you all. In this particular case, let's point out that sometimes when there's cultural or language differences in the workplace, that can be a risk factor. Here we saw, again, somebody with more power, right? This particular power, since he acted as translator and he was a manager, and he was the night shift manager. On the night shift, not as many people around, so that can lead to greater vulnerability. And also we see often in restaurant or other industries where you have to please people, that can enhance the chances that there's going to be harassment. So we just thought we kind of bring those items forward, and thank you again for participating in the training so we can reduce the risks of harassment. So again, as we start thinking about harassment, we're going to put a quick quiz in front of you. I'd like to ask you all, you can respond in the chat. Think about this. Can you prove harassment if the person never explicitly said, you got to sleep with me to get this job? What if they never say anything? They just kind of do something or act creepy. Will it become harder to prove if they never say it out loud? Or what happens if there was interaction? What if the person who was targeted flirts back or actually gives in and have sex in order to get the job or to keep the job? Does that rule out your ability to complain about harassment? What about this? And we see this all the time. What if there are no witnesses? I don't know if you noticed in the illustration before, but we know the person who testified said he always seemed to wait until there was nobody else around before he touched me, right? So what if there's nobody there, right? That's often the mode of the harasser, right? Isolated workplaces. If there's nobody who saw it and it's his word against your word, can you still prove harassment? I see a no in the chat. That makes me very happy. I'm going to turn it over to Bill to establish the elements of a hostile work environment.
Okay, so the most of the egregious sexual harassment, as Linda said, happens behind closed doors. That's an important element because what the harassers will say is, nobody will believe you, Maria, because nobody saw it. And that's an important factor because that will come into play because she's been told all along, you don't have power, no one's going to believe you, right? So just remember that, because that's when, from the day she walks into your office or you start talking to her, that is always going on throughout the whole proceedings of whole length of the case. So what is really sexual harassment? So it's unwelcome conduct, either physical or verbal, right, of a sexual nature. It's got to be of a sexual nature, either verbal, it could be touching, it could be words and all this. And so what the courts look at is it objectively offensive to a reasonable person? Would she feel offended by these questions? And would a reasonable person feel offended? Would she also subjectively find it offensive? So many of our cases start with the grooming. Like, you know, gee, Maria, you look really pretty today. You look nice. I really like you in that dress. Could we go out for coffee today? Could we go out for dinner? Now, some will say, is that sexual harassment? Well, not quite yet. He hasn't said anything yet, quote unquote, of real sexual nature, and that a person would find so offensive. But then, particularly in our agricultural cases, it always starts with, you know, I could take care of you and your kids and your family if you would just, you know, have sex with me. Or it will be other things, you know, start sending cards, start sending texts, and then it escalates into touching, grabbing. Then you're starting to talk about, well, would a reasonable person find that offensive? Now, there's one thing, touching on the shoulder, say hello, as opposed to touching on more private parts, then it starts to cross the line. Then the law says the conduct has to be either severe or pervasive. So for sure, a grabbing, sexual real assault, you know, that could be severe and you don't need to have a whole lot of it. One of them might be enough. Pervasive usually is addressed to words that are used throughout the workplace, where the harasser, for example, keeps asking her about her sexual life, talking about his own sexual life, talking about the kind of sex they could have, all those kinds of things. He never touches her, but he just uses all these words. We would say that's a hostile work environment. It changes, it gets so severe or pervasive that it changes her working conditions, that it's unbearable for somebody to be able to put up with that. Okay, so those are the things we really have to show in terms of what is a hostile work environment. And usually a hostile work environment can happen, what we look at is whether the employer knew or should have known about it. And that starts to get the employer into trouble in terms of liability. And we'll get to that in the next slide.
Just a quick addition here. In addition to verbal or physical touching or verbal comments, it can also be visual, right? Like if there's something present in the workplace, I have here an image of graffiti, and that's my illustration of something that could be visual and also might be a should have known. You can't say, well, I didn't go in and see that. If it's painted on the walls of your facility, you probably should have known about it.
Yeah, good point. Part of my screen's unfortunately covered here. Right? So we have different forms of harassment, right? All of them are of a sexual nature, unwelcome. So then we have the classic one where you have a manager and a supervisor. Most of the cases we've litigated involve a manager and a supervisor utilizing his power. So he could do all those things of, you know, propositioning for sex, targeting her, or also just being abusive towards all the women in the workplace and making it in a sexual context. That's part of the hostile work environment. But what we also often see in our low-wage worker cases is what we call quid pro quo sexual harassment, where the manager says, You want a job, this is what you got to do. You want to keep your job, this is what you got to do. You want a promotion, you want more hours, you got to have sex with me. You want to make sure and we get this in agriculture, you want to make sure your brother doesn't get fired, this is what you have to do. So when the employer or the harasser conditions further work or has work or hours, etc., it's conditioned on having granting sexual favors. We call that quid pro quo, a classic this for that. If we can prove it, the employer is immediately liable because the employer, the supervisor or manager is acting as an agent of the employer. But let's say it's not quid pro quo and it's the hostile work environment. The employer, again, could still be liable for the acts of the supervisor because, again, the employer has to make sure it's a safe working place for the employees. So again, the harassing behavior can be directed towards Maria, or it's something that Maria sees that maybe it's targeted to other women, but she clearly hears it and sees all of it. It affects her own working environment that it also creates for her the hostile work environment. Next slide. So some of the examples, I said, always builds up from slurs, advances, comments, etc. All of these things are pretty common. In the religious and national origin context or racial context, it could just be words a lot of times, the N-word, nooses, all these kinds of things that are just general examples. Next slide. So let's say there's a non-supervisor. The employer, and a lot of times in our young worker cases, the other harassers are co-employees. They're not managers or supervisors, particularly where a lot of teen workers or young workers are involved. The employer is liable if the employer knew or should have known that the harasser, that the harassing was going on, and then the employer failed to take prompt and corrective action. That usually means they investigated and then they terminated or suspended the harasser so that the harassment stops and it deters future harassment. So I mentioned coworkers, but sometimes third parties can be harassers. So for example, let's say Joe delivers water to the office once a week. And every time he goes into the office, he harasses Rachel, the receptionist, and starts talking about wanting to have sex with her all the time, commenting about her body, etc. So once she tells her manager, or the manager observes all this, the company is on notice that this guy is harassing Rachel, that Joe's harassing Rachel, and the employer has to ensure it's a safe workplace for Rachel, and so the employer has to take steps to protect Rachel from Joe's harassment, or else the company could face liability. Next slide. Just 16. Yeah, go ahead. You're 17. Go ahead, you're.
So we just want to, again, I think it helps to get an idea of what harassment could be, but we want to make sure you're not thrown off track. And so here's our little quiz again. Feel free to respond in the chat. We talked about earlier, does it matter whether the person who's doing the harassment explicitly says, you know, you have to have sex in order to, you know, get this reward or to avoid this punishment? But here's another question. Does it matter if the person who's being targeted for harassment doesn't say this is unwelcome, right? We talked about, was it welcome or unwelcome? Do you have to say no out loud in order for it to be clear that it was unwelcome? What do you think? Yes or no? And again, I think I asked this earlier. Does it matter if the person, you know, they want to keep their job, so they kind of go along with the behavior? What if they said yes or participated? We kind of already talked about this, right? Okay, I'm seeing good answers in the chat. What happens if a relationship starts consensually, right? What happens if they decide, you know, they wanted to date this person? This is their dream of a person. They trusted this person. Does it matter if it started consensually? What do you think? Sometimes we have had cases where drugs and alcohol were involved. In fact, in a recent case, they all went out to a holiday party and there was lots of drinking going on. And then as the worker was waiting for her boyfriend to pick her up, she was alone in the hotel room with the supervisor and he attacked her. Does it take away from the case if there were drugs or alcohol involved, right? What about the person said, oh, well, that wasn't what I really meant. I was just joking. What happens again if it didn't happen at the workplace, after hours, at the holiday party, or getting a ride to work or from work? What happens if it only happened once? And again, we return to that theme because this often seems to throw people off track. What if it's a he said, she said, there's no witnesses? And while I know Bill has been using she pronoun a lot for the target and he for the harasser, let's just say we do see cases of all types, right? So
And I think one thing to add here too. So all of these hypotheticals actually come from real cases we've litigated and obtained good settlements for the people, the claimants in those cases, despite all of these facts coming into play.
So the theme of this case, I have a red fish for red herring. We hope that it doesn't let people think, oh no, that destroys the case. It doesn't, right? These cases, this is what happens in real life. And these are not determinative of was it unwelcome, was it illegal? Don't let these things throw you off track.
Okay. So in Tiffany Graben's case, how we get this case to the EEOC is Tiffany's mother comes home one day and sees Tiffany on the couch crying and in a fetal position and sucking her thumb. And normally Tiffany's a very bubbly teenager. She was still in high school here in San Jose, working at this shoe sales job. And the mother asked her, well, Tiffany, what's going on? And Tiffany tells her that she's been at her job, it's a holiday job at a shoe store, and the assistant manager is constantly propositioning her. And then he invites his friends to come and check her out. And then he starts talking about sex with her and all this. Tiffany complains to the store manager about the assistant's behavior. And then the assistant, tells Tiffany, you better not get me in trouble again. If you do, I'm going to do something to you. And so it stops for a while. And then the harassment resumes and it escalates. And she complains again to the manager. And the manager tells the assistant to knock it off again. But he doesn't fire the assistant manager or discipline him because the manager is dating the assistant manager's mother, if you can believe this. But after the second warning, the harasser corners Tiffany in the back room of the store and puts his hands around her and says, if you get me in trouble again, he puts on her neck, I'm going to break your neck, and completely just traumatizes her. She's really upset over this. And so she comes home and she's crying, and the mother sees her, and the mother listened to her, didn't doubt her, and then brought her to the EEOC. And then that's how we get the case. And we settled that case for like $11,000. Really, the bulk of the money is for her emotional distress, for her pain and suffering that she endured during that time of harassment, and particularly under that threat. And fortunately, Tiffany, for a few years, she was a spokesperson for our Youth at Work campaign. So the important quote here is, just because you're a teenager, that doesn't mean you don't have rights. If you know your rights, you're able to stand up. And I use this also to educate bystanders or parents to say, look, here it's important to listen to your kid, let her talk and tell you what's going on. Next.
Oh, Bill, I just wanted to also use this case to illustrate what we said earlier about you don't necessarily have to be the target and also third-party harassment. So obviously those facts are really appalling, but I remember in this case, one of the things that happened was that assistant manager would hang out in the store and like he would make comments to other store employees
No.
and they would check out customers and they would make comments about the customers' bodies within Tiffany's earshot, right? So just because the harassment is not directed at you, but you're witnessing it, this is just to illustrate that thing Bill was talking about. It doesn't have to be aimed at you for it to offend you or affect your workplace environment. So that was an example of other forms of harassment. Okay.
Okay, next one. Then we had a case of, so in this case against the old Fry's Electronics before it went bankrupt. So America Rios is a 19-year-old sales associate, and she's getting texting messages by the assistant store manager, Ibrahim. She shows them to her, one of the immediate supervisors, Ka Lam, a 25-year-old Chinese-American supervisor. And for Rios, this was like pretty shocking. The texting is like talking about her body, propositioning her, inviting her over for drinks. She's 19, and Ibrahim, the harasser, was like in his late 30s. So she shows these to Lam, and Lam says, well, you know, that violates the company's policies. And but he doesn't report it to the store manager because he knows the store manager, Mr. Squires, is good friends with the harasser, Ibrahim. So Lam contacts Fry's Electronics, which was based in San Jose, and tells them about these texts. And I use this case to show how an employer can really screw up. So Squires has to go down to San Jose for a regional meeting, and one of the human resources individuals approaches him and says, we're getting these messages from Lam. You should check it out when you go back to Seattle, which is where the store was. So Squires flies back to Seattle and demands a meeting with Lam and Rios and says, he doesn't even ask them about the text. The only thing he says is, you need to show more respect to the assistant manager. That's all he says. And then a couple days later, Mr. Lam is suspended. And then a week or two later, he's fired, allegedly for having poor sales, even though he had just been promoted for having excellent sales as a sales associate. So we brought this lawsuit, and we eventually settled that case for $2.3 million. We alleged that Lam had been retaliated against for reporting sexual harassment, and then Rios had been sexually harassed, and she needed compensation for that too. But the whole point here is that here, Mr. Lam did the right thing. He listened to the employee, what didn't decide, like in a lot of our cases, the supervisors just say, oh, don't deal with that. That's the assistant store manager. That's how he is. He knew his job was to follow the company policy to report it. And so he did that. And I think what Ms. Rios said at our press conference, was she said, this was my first job. It really meant a lot to have my supervisor speak out for me. And it was horrifying to see him lose his job over it. So it's really what a bystander does and then what a good supervisor does in response to an employee complaining of harassment. Swing it over to you, Linda. You're muted.
Yes. So hopefully these are giving you some ideas about how to spot harassment. Again, as a reminder, I think we've said this before. It could be behavior that's verbal, visual, physical, and in the case we just talked about, virtual, right? Online harassment is happening now. It could take place at the workplace, or it could take place away from the workplace. It could take place online. Let's be clear that the harasser could be any gender, whether it's opposite or same sex. And the harasser could be, we often think of it being as like a supervisor, somebody with power in the company, but also could be a coworker or somebody who's not employed by the company, such as a customer or a delivery person. And it doesn't have to be based on sexual attraction. Sometimes it's all about power. The victim or the person who was targeted doesn't always have to be the direct target, as we mentioned before in that Tiffany case where she observed them making comments about women who came through the store, and it wasn't directed at her, but it made her feel uncomfortable. That's what we're talking about there. Our analysis for harassment, our focus has been on sexual harassment, but this analysis also extends to any of the protected characteristics that Bill described earlier, right? So it doesn't have to be sexual, but it could still be based on gender. It could be also based on race, color, national origin, religion, disability, or age. And just to give you some examples of other forms of harassment, I'm going to describe two cases. In one case against a Bay Area car dealership, we had a number of Afghani and Muslim employees who were called, as we mentioned before, slurs or epithets based on national origin and to some degree religion. They were called terrorists and thieves and Osama bin Laden. And what's interesting was this case was actually before 9/11, but after the bombings of the US embassies and the USS Cole. And in terms of color, you know, there were there was a larger number of Afghani employees in the finance department. And at a meeting, one of the supervisors said, "Oh, it's getting dark in here. We better turn on the lights." And so that was a reference to the fact that, you know, there were more people of a dark skin color in the meeting. And in part, we're also sharing this story because, you know, one of the employees who was, you know, fresh out of school said this really impacted the way she looked at work, right? She was like, I don't know if I'll ever feel safe again. So that's another reason we prioritize our youth at work outreaches. We know this experience can shape how people see work as they move forward in their careers. Another example that might be resonant with what's going on currently, I brought up an example of a case we brought on behalf of a Chinese construction worker who was working on building, you know, that 3rd Street rail for Muni, yeah. Right? And so even though the person who was harassing him was not his direct super, he was the foreman. There was a white foreman who said things like ching chang chong and then used an expletive Chinaman, right? And again, the pattern we see is although Lynn complained to supervisor and other people in management, nothing was done to address or stop the harassment. And actually, Lynn wound up getting laid off without explanation. So we alleged discrimination and retaliation. You know, and we're able to get him some relief and, you know, a monetary settlement. So here are a couple of examples of harassment outside of sexual harassment. I know that we've just thrown a lot of information at you, so I'd like to invite you to stop and kind of reflect about what we've told you about harassment. I know it's a lot of information, but I find that when you write things down, it helps things to stick in your memory. So I'm going to urge you to write down maybe 1 or 2 things that have really struck you about harassment, right? Go ahead and take a minute. If you do this, hopefully it'll help you remember it. And to further make it stick in your memory, I've always found that teaching people the information you just learned is the best way to master that material. So I also urge you, as you write down what you want to remember from what we just spoke about, think about at least 2 people who would benefit from this information, right? It could be people in your workplace, it could be people in your life, your family. But by sharing this information with other people, I'm hoping it'll help fix these ideas in your head, right? So what is it that you've learned now about workplace harassment that you can apply and maybe share with somebody else in your life? Okay, turning it over to you, Bill.
Okay, so how do we prove these cases? So your role is to help document what she's telling you, right? So sometimes you're going to help her tell her story. You ask her to describe details. You say he touched you, Maria. Where did he touch you? Where did he grab you? How frequently? How long did he keep his hand there? Where did this happen? You know, and then if she says, well, there's a lot of verbal harassment, you want to ask her, what did he say? Like, for what? What example? You know, and because that helps build the story, and then we know a fuller picture. And then one very important thing to always ask her, were you threatened by anybody, by the harasser? So he says, you know, you tell anybody, I'm going to fire you. You tell anybody, I'm going to make sure your brother loses his job. Or was there a manager who said, oh, come on, Joe's not that bad. He's got a family to feed. Why do you want to make trouble for him? Right? Or do coworkers shun her? You know, they all of a sudden just ignore her. Or if she's had the opportunity to go to human resources, are they telling her to just drop it? So we want to look at is, was she discouraged from complaining? That's an important element to be able to, for us to look at. And then obviously you want to ask her, is anybody else harassed? Maybe there's other teens in the workplace, other young workers. And then if she complained, who did she tell? Ask her, did you complain to anybody? And aside from somebody in the company, did you just tell anybody? She said, I told my mother. That's important, because then we could talk to the EEOC, go and talk to the mother and just say, well, what did Maria say to you? What did you hear? So it helps to build up her story. So in most of these cases, there may be no other witnesses, but at least if once we get her to tell her story, then we can, you know, build up the facts around it. And we also need this so we can assess, you know, her credibility fairly and reasonably and see how she would be able to stand up in later proceedings of the case. Next thing, next slide. Again, as a counselor or advocate, make sure you're documenting this. You will be a critical person who may have to testify to say, yes, when Maria came, she was trembling. She was crying. She was so upset when she was telling me what happened. She says that Joe stuck his hand in her panties and kept it there. And she was crying when she said this. And that form of harassment is actually a true fact from a case we litigated, again, out of Oregon for a 21-year-old farm worker who'd been constantly propositioned by the supervisor. He corners her in an office, starts kissing her, sticks his hands down her front of her pants, inside her pants, and then she has to fight him off. And after she fights him off, he fired her. That was the case. Simple facts, and we got her a $260,000 settlement. But then again, we also know that she could be describing something very physical acts or very disturbing acts, but yet remain stoic and kind of giggle while she tells her story, thinking that maybe you're not going to take her seriously. But so there's no one way for somebody to respond when she's traumatized. The important thing is for you to document your observations, write down what she said to you, because your notes might eventually be something that helps establish your case later on. Next. I know many of you are dealing with the criminal justice system where we have to prove cases beyond a reasonable doubt. That's not what we're involved here. We are in a civil proceeding where all we have to do is show the jury or the judge that it's 51%. The facts lean towards the claimant's position. So in EEOC versus Harris Farms, this is a case where Olivia Tamayo had been raped 3 times at gunpoint by a supervisor, and all behind closed doors, are out in the fields. And after each time he raped her, he told her, if you tell anybody, I will kill your husband, who also worked at the farm. Eventually, Olivia was able to tell her story to a deputy sheriff. Unfortunately, the deputy sheriff didn't speak Spanish and relied on the human resources assistant manager, Sylvia Gomez, to translate. And Sylvia Gomez says, well, we've been thinking that Olivia and Rene Rodriguez have been having an affair all these years. We don't believe her. And the deputy sheriff says, well, I don't believe her either. Fortunately, when we took that case to trial, in a civil trial in Fresno, the jury came back and awarded Olivia nearly $1 million. So you're all very aware of what are the obstacles for reporting. It's the fear, shame, isolation, threats of immigration status, the need to support her family. Sometimes the family is pressuring her to just drop the case. And there's trauma that's operating 24/7 as she deals with her experiences. Fortunately, at the EEOC, the whole purpose here for us is to really show you that we can investigate these cases. We can get temporary restraining orders or injunctions to stop the harassment. We can provide her a U visa certification. I'll get into that later on. And we want to partner with you and all the other community advocates. Next slide. So in talking with her, and I'm sure many of you have had this training, right? We know that it takes a lot of courage for a claimant to come forward. Never say, why didn't you say something earlier? Because it puts the burden on her. And you can ask her, did you try to talk to anybody about it? And sometimes they didn't tell anybody because they've been threatened. Like in our case of Harris Farms. If you tell anybody, Olivia, I'm going to kill your husband. And one of the other factors is she's bombarded with he said, she said. And she's told, well, no one's going to believe you. It's your word against his word. But remember, we've litigated these cases and it was he said, she said, and we've won. So just because there's no other witnesses, that doesn't mean she's lying. And so your evidence, your notes are going to be critical evidence in her case. You're helping to build the record. And the important factor here is if any hint from you as the counselor or advocate, any hint from you that she's not believed, she's kind of off, she's gone. She's not going to come back. And so part of our training with our own investigators is to do trauma-informed training and to remind people, don't give her the concern that, or image that you don't believe her. Let her tell her story. Next slide. So unfortunately, despite the Me Too movement and more talk about civil rights and equal employment opportunity, retaliation is the main form of discrimination we're seeing. So in 2005, there were about 30% of our charges. Now they're 56% of our charges. So in nearly, I would say, I can't even think of one sexual harassment lawsuit that didn't have a retaliation claim. It's very common in sexual harassment and racial harassment cases for the employer to fire the employee, to suspend the employee in retaliation. And I will tell you, in all of our low-wage worker sexual harassment cases, they didn't come to the EEOC complaining about harassment. They complained that they were fired. They didn't take action until they were fired, which means they put up with a lot of harassment for a long time until they finally said no, and then they're fired. So what the issue is, what the courts look at is, did the adverse action, being a termination, demotion, suspension, etc., did it discourage the reasonable employee from pursuing her complaint? That's what we look at. So for you as the advocate who may be talking to Maria for the first time, always ask her, were you discouraged from making a complaint? Who said anything? Who threatened you? When did this happen? And how often did this happen? And do you know if anybody else has been threatened or deterred? So that's all critical information in there. So by the time she's come to you to tell her story, she's put up with a lot. And sometimes it's the retaliation is the quote unquote straw that breaks the camel's back that finally gets her to come forward, tell her story. Next line. So, are you doing this part, Linda?
I can.
Okay.
So why should you file a charge with the EEOC? A lot of things that people tell us is they wanted to make sure this never happened to somebody else, right? That's often the motivation for people. As we saw in Tiffany Graben's case, her mom was the one who gave her the information and urged her to come forward and made a big difference for her. What happens when you file with EEOC, right? In order to pursue your claim in a court of law, you do need to file either with the EEOC or with your state agency, right? That's part of the way the laws are designed around harassment or discrimination. What we can do for people is investigate the case. We can get access to more information that you as a layperson could get, right? We can see if there were other people who were harmed. And in our remedy, we can take care of the person who came forward to us and any other victims who are involved or targets involved in the case, right? And what we try to do is to obtain a remedy that will make those people whole, which is typically a cash settlement, right? Money settlement and other relief to make sure that that employer doesn't go ahead and do the same kind of discrimination or permit the same harassment to take place. So those are the reasons to come forward and file with EEOC. Currently, we don't have in-person intake due to COVID-19, but we are still taking intake via phone and mail. And through our website, you can set up the intake appointment, or you can call our 800 number, or I'm also going to share my phone number and email. You're always welcome to contact us. Again, just to kind of take you through what the process looks like, typically what happens is EEOC takes a charge, most typically from the worker. Bill's going to talk about this, who can file a charge, in just a second. But normally we find out about the case. We have the power to investigate it and to make a finding. In that initial period, we're a neutral body, right? We will get information from the people who file the charge, most typically the worker. We will ask the employer to respond. We can subpoena information. We can go into the workplace and do on-sites. There's a number of investigative tools that are available to us. I'll also point out that we have the power to mediate. So again, if both parties agree that they don't want to go through the entire process, we do offer an opportunity for both sides to sit down and avoid the legal and bureaucratic proceedings and see if they can come to a mutually satisfactory resolution of the case. But if that doesn't work, again, we investigate, we make a finding. If we find no cause, that doesn't necessarily mean the end of that case. We issue a right to sue letter, and the party can go on to have a private suit. And some people have gone on and proven their case in court. If we have found reasonable cause, as Bill had mentioned, right, tipping over to 51% or more, if we find cause using that standard, we stop being neutral and we become the advocate, and we try to conciliate. And again, our goal is to make the party who suffered discrimination whole and prevent future discrimination. So we're thinking about the public good, and that's what we look for in a conciliation. If we're not able to conciliate the case, we then have the option of taking it to court ourselves. EEOC can litigate those cases, and those are the cases that Bill has been describing to you. Yeah. Throughout all of this process, you don't have to come and pay a fee to use EEOC. It's paid for by tax dollars. So if somebody comes to us, they don't need to pay a fee. They don't need to bring an attorney. Some people choose to, but you don't need one to come through our process.
So can I just add here? So as a district director, I'm the one who signs the paper to say, yeah, the EEOC has concluded that discrimination has occurred. Okay, so that's the reasonable cause finding. And then now we're no longer quote unquote neutral. We're like, so in the first investigative stage, like the EEOC is kind of like the police or the FBI trying to dig up the facts. But then once we've made a finding that, yeah, we think a law has been violated here, then now we are standing as a party to the case and saying, okay, in order to make Maria whole, employer, pay her $20,000 or $30,000 in back pay and $200,000 in compensatory damages, so we can make her, whole, and make sure that Joe is fired. And then you train all your employees about sexual harassment law, how to report it, etc. So if we settle the case in what we call conciliation, that all stays confidential. Nobody knows about it. And in fact, even during the investigation, we can't tell anybody we're doing this investigation unless there are witnesses that we need to talk to. So oftentimes people will call me and say, oh, we understand your EEOC is investigating X and X employer. My response, as required by law, is to say, I'm sorry, I can't confirm or deny the existence of any charge that the EEOC has. But once, and then in the conciliation, I can't even talk about the settlement. I'm prohibited by law from talking about it. However, if it doesn't settle, in conciliation, and we go to court and file a lawsuit, then everything's public. And we usually issue a press release that says EEOC has sued X and X company for sexual harassment against, workers at this plant or at this store, at this restaurant. And that becomes a matter of public record. Yeah.
Bill, we've been asked, can we comment on how long these processes are?
Yeah. So yeah, I saw that in the chat, and I think, wow, there's no one formula. It really depends on how complex the cases are, how many people we need to talk to in the investigation. Sometimes it can take months or years to get through, and then hopefully we can make a finding. So it's a side note to it, but this is a real challenge for us, for the EEOC and for advocates, is how do you sustain a claimant throughout what could be a long process to be able to get her relief. And it's not a perfect process, but sometimes it takes some time to get through. And so your role to help being a sense of support from her can be crucial. It's crucial.
And so sometimes mediation is one way of speeding through that's usually a faster alternative. And Bill, I'd just like to point out, if we sense that there's physical danger, we fast track those cases, right? Yeah. We have tools. And so maybe as we move forward, we can address that.
And generally, we won't send a case to mediation. If Maria says, well, it's me and there's 5 other women who've been harassed, then we know that's not the case that has to go to mediation, because what the employer will do is just nickel and dime them all for a really low settlement. And we know there's bigger issues here. Next slide. So who can file a charge? I said this again earlier, it's anybody who's working in the United States with 15 or more employees. Third parties are critical because sometimes the workers are scared to come forward to complain. So sometimes it's been a union, a church, even a sexual assault program can come to the EEOC and say, we understand that there are X and X women being sexually harassed at X and X plant, okay, to get it all rolling. In fact, one of our earlier cases, big egregious farm worker cases, it came from the Iowa Coalition Against Domestic Violence, Sonia Pata-Conrad, contacting me and saying, hey, we're hearing about women being sexually harassed in DeCoster Farms. Eventually the women came around, but we could have used the Iowa Coalition of Domestic Violence as this first start to start the investigation. And then at the bottom are 5 commissioners in Washington, D.C. Any of them has the authority to sign a charge and say, okay, Bill, San Francisco office, go investigate this case. Okay. So immigration status is a big issue. So there's a lot of fear in the immigrant community that you can't come forward and you're not protected because you're undocumented. So before I joined the EEOC, I was one of the lawyers for Alicia Castrejon in a pregnancy discrimination case called EEOC and Castrejon versus Tortilleria La Mejor. And there, Alicia had been hired, goes on maternity leave, and then the employer refuses to take her back after she has her baby. That's the simple facts of the case. But somehow the employer learned that she was undocumented and argued to the court that she's no longer covered by Title VII because the Immigration Reform and Control Act had originally barred her hiring or rehiring. So we got a ruling from that court that says, nope, Title VII makes no distinction based on immigration status. Castrejon is protected. EEOC can pursue her case. So during our investigation, we will not ask immigration status. So that's important. The investigators aren't. And then you also know, even though our investigations are confidential until it gets into litigation, what you tell our investigator could also be factually information that could be revealed, might be revealed later on in litigation. So never mention immigration status in any written form or anything like that, because that's not going to help her, right? We don't want that information in part of our administrative investigative file. If we, well, the other part is this. So she has no confidentiality privilege with the investigator. So that's critical to know. So we tell them, look, it's going to be kept confidential as long as we can, but sometimes it may come up in litigation. But so that's why I don't really want any written factual record about immigration status, because it's irrelevant. It's irrelevant to whether she was sexually assaulted or not. Now, if we're in litigation, we will fight off all the inquiries into immigration status during litigation, and the courts basically go along with us and issue an order, protective order, barring any questions about immigration status. But suppose, it's very serious criminal activity, egregious sexual assault, she would probably qualify for a U visa. If she wants a U visa, she needs to contact the EEOC regional attorney or trial attorney. And we'll have all that information. You can go on our website and you can see who is the regional attorney for your area and contact that regional attorney directly on our website. The reason why we say contact the attorneys is because they will be the ones doing the certifying, and we can assert a quasi-attorney-client privilege between the claimant and the regional attorney, because he's helping further her legal process in the country. And so we say that they have a quasi-confidentiality relationship. I hope, any questions on immigration status? And I'm monitoring the Q&A.
I didn't see anything directly on this, but I would say, yeah, feel free to also just reach out to us, and I'm happy to redirect you. You can look on our website or contact one of us.
Next line. And then, so the other part to remember is timing. So timing is you have to file a charge with the EEOC before going to court. Generally, it's 180 days. But if you are in a state, for example, like California, and you have 300 days to file a discrimination charge with the EEOC, because we have a agreement with the state agency. Also look at your state law, because sometimes it may be a longer time, like California has a 3-year statute now. And then the issue is, when does the clock start? The clock starts when in termination cases, when the employee is actually notified. So today on March 30th, if somebody says, okay, on March 30th, tells her, Maria, on March 30th, your last day is April 30th. Her clock starts running on March 30th, the day that she's notified. Now, what happens if you have a whole pattern of harassment? Which clock do you look at? It's been harassment over a series of months or years. So long the last act happens within the last 300 days, we can go back and pick up all of those acts of harassment and investigate and get relief for all those acts of harassment. Now, suppose she's really late, and this is our next case. And the only way I could illustrate the next slide is where is when a case where a farm worker, Floriberta, is sexually harassed at Willamette Tree Wholesale, a farm in Oregon. And she complains and says, stop it, I don't want you guys harassing me, and she's fired. That's the case. And so if a co-employee says, you know, Flora, if you go to the Oregon Law Center, they can help you get your job back and maybe get your last paycheck. So she goes there, and then the lawyers ask her, well, is there anybody else who may have been harassed? And she says, well, you know, my sister Emiteria hasn't been the same since she was fired from Willamette Tree. So they say, bring her in. So she comes in to their office, and she tells this bits and parts of the story that on or about the first day of work, the supervisor brought her to a room with machinery, and she saw flattened cardboard boxes. He throws her on the cardboard boxes, puts gardening shears to her throat, and proceeds to rape her. And after he rapes her, he says, if you tell anybody, I will kill you, your brother, your sister, and your brother-in-law who work here at the farm. And what we eventually found out in the story is that for the next 10 to 12 weeks, he took her on his motorcycle, brought her out to the fields, forced her to perform oral sex on him. And after every episode, he said, made those same threats. And the last incident, she says, well, I can't do this anymore. My throat's damaged, and he fires her. So what happens, I eventually get called by one of our trial attorneys in Seattle, Carmen Flores. She tells me about it. And so I said, meet me in Portland. So we just went to Portland the next day, and we met Emiteria. And it was very painful because she was just so traumatized. And she had been a recluse for about a year in her own house. Didn't just go, had little bits to eat, did stop going to church, stop going to markets, stop socializing. This was a family of farm workers who had no more than a second or third grade education in Mexico. They all lived together. And then we were trying to figure out her deadline, and we said, oh my God, she's 62 days late. What are we gonna do? And we said, nope, we're gonna take the charge, and we're gonna argue that the company can't benefit from having traumatized her so badly that she can't come forward to tell her story. And we relied on a case out of Sacramento called Stoll versus Runyon, in a case where a postal worker was raped several times by supervisors and then fired in retaliation. And she couldn't file her lawsuit in federal court on time, even though she had a lawyer, because she was so traumatized she couldn't work with her lawyer to put her case together. And the lower court dismissed the case on timeliness grounds, saying, sorry, you know, she's 10 days late. But the Court of Appeals reinstated the lawsuit and said the company, the post office there, couldn't benefit from having traumatized her so badly that she can't complain. And so fortunately, we're able to use that case, and Judge Papik in Oregon agreed with us and allowed us to proceed with our lawsuit, and we were able to obtain a settlement. So the whole point here is, even though she may be late, send the case to us. Send the case to us, and then we will look at your notes, because you're going to say, yeah, when she was telling her story, she was trembling and crying. She clearly looks like she's traumatized. That may help build the case. And in Emiteria's case, we had her go to a psychologist and a therapist who produced a report for the court that just shows how badly traumatized she was. And okay, excellent. Next slide. I guess we're it. You're on to you.
Yeah. So just as a reminder, I know we're giving you a lot of information but again, as we kind of wrap up what we're talking about, here are our typical tips for other workers, right? It's really important for people to know what their rights are, so that you realize that EEOC can be a tool in your toolbox as you encounter this kind of behavior. And there's a spectrum of behavior. We've tried to share with you a range of cases. Some things are really horrifying and dramatic and traumatizing, and other things may be, there's a spectrum of behaviors out there. But it's important for people to know what their rights are. In our general outreach, again, we talk about like, how do we make sure our behaviors are not considered harassing against other people? So just realizing how different people may receive things, receive comments, it's good for us to be conscious of these things. And ultimately, especially to this audience, we want to talk about what are ways in which we can be an ally or an upstander for other people, right? It's important to kind of call out negative behaviors, make sure people know what their rights are, and to support, you know, your colleagues and coworkers. We want to encourage people to report discrimination. And there's a great question in the Q&A that I'd like to work in here, right? So it's EEOC stands to say it'd be great to report it to the company if possible. We've described some situations where there's clearly been retaliation and that chills people out, right? So everyone has the right to report to an agency like EEOC or a state agency, try to meet it before the deadline. But even after, as Bill has said, there may be hope for the case. Come and let us know and we can advise you what the situation is. And as we said before, it's so critical to keep records. So this is something that the worker can do, and this is something that we're hoping that you as an advocate may also help the worker do by thinking through, when did it happen? Where did it happen? What was said or done? Were there any witnesses? Not that that should be determinative of a case. Moving on to talking about your role, right? That's what this whole training is about. We're hoping that you can listen carefully and without judgment. We're hoping that you can act as a witness, right? Even if there's not a direct witness to the harassing incident, it may be that your testimony as the person that they told could be very powerful and persuasive, right? And so in that case, your observations, what the person said to you, all of these things can make a big difference. And we all know that people respond to trauma in different ways. So there's no one right way to respond to trauma. Your job is just to respond to the individual in front of you and not pass judgment.
Hey, Linda, I just want to, there's a good question that's really on point on this one. This is the question from, about how can you tell your story without feeling interrogated?
Yes.
About the credibility.
So do you want to take a swing at answering that?
So I think, this question has come up quite often when I've spoken to folks in SA or DV programs. And it's not an easy answer, because asking her to recall what happened is in and of itself traumatizing. And it is a certain sense of interrogation, and you're trying to assess her credibility. And unfortunately, that's what we're going to have to do. It's a question of how we ask the question so that we feel like she's being asked to share her story and share her experiences so that we can help her. But if you ask a question in a very, harsh way, or did you do this? Did you do that? Did you do this, that? Then it's like interrogating your kids and they never want to answer you. And we know, because the experience and the trauma are so tremendous here, and she's in a very sensitive position, how you ask the question will determine whether she's even going to stay involved in the case. So just be cognizant of that. I don't think you totally escape the whole point about asking her, because you want to get her story out. And sometimes they can't get their story out. They don't know what facts are the important facts to share with you. You have to guide her through the process.
Maybe adding on to what Bill said, I know when we conducted internal training on trauma-informed investigation, it may take a while. It may be, I don't think this is a one and done situation. If someone trusts you enough to come forward, it's great to make them feel listened to and just let them tell their story in their own fashion. It may be that at that moment is not the right moment to press them. You kind of need to use your judgment, right? You may have questions in the back of your mind, but maybe at this initial moment, it's good to kind of listen, prompt in open-minded ways, try to avoid questions that are very closed or kind of drive at certain things. But I can try to think if we have resources to share on how to do trauma-informed investigation. I know there's trainings out there, but again, I think it's about listening carefully, making sure you have enough time for it. It may not all happen all at once. I think sometimes we get in a mode of problem solving, which gets in the way of listening, right? So it may not all happen at once. It may happen over a couple of conversations. So when we say to you that here are some questions that would be helpful to know, we're not saying you got to get them all answered on this first go round. So I'm hoping that helps to answer this excellent question, right? Because I think it's a challenge we at EEOC and you all will be facing. And ultimately, I think by you educating yourselves as to this process, you're gonna be an ally and a resource for this person. But you don't have to know all the answers. You can loop us in and we can figure it out together. I think I just have a few more slides I wanted to share.
We're at
time. Oh yeah, okay. Okay, let me move forward. This is a little off topic, but I know the coronavirus is going on right now. We just want to make sure that if you have questions regarding EEO issues and discrimination and the coronavirus, we have a resource on our website. And here is Bill and mine's email and
we got to update those numbers.
We have updated numbers. Sorry, we just changed our numbers. I'm going to send you correct numbers through Shirley. All right, any other questions?
Yeah, no problem. If you want to send me those numbers, I can share them with the attendees in the follow-up email. Yeah, so I know we're at time, but if you have any remaining questions, maybe drop them in the chat box or send them to one of us through email, and we'll do our best to get the answers to you. I want to thank Bill and Linda so much for coming on today to share about this topic. I know that given that all the focus, or there's a lot of focus, and rightly so, on harassment against Asian Americans today, this is relevant, very relevant, and I hope that this has equipped many of you with some of the tools and information to be able to help the young folks, and not just young folks, but older workers that you work with as well.
And I do want to offer that I know many of you come from programs from all across the country. If you want a training specifically for your place of work, your employer, your employment, or your agency, or maybe you're in a coalition in a certain city, and you want to organize a training with the coalition, we'd be happy to do this kind of training again. Because I've reached out to, I've done the trainings for the coalitions in Northern Nevada, Anchorage, Boise, Seattle, Portland. So this is very easy. We could do these trainings too. And even, hopefully when we go back live, and we can I can, send people out, or I can contact somebody from our other offices to go do training live with your organization or coalition.
And we're happy
Thank you.
to continue to provide space for that as well. Just one question, I think you can answer this very quickly in the chat. I think Linda maybe was the one who mentioned that the PPP would be available on the website in about a week. Okay, yeah.
I will fix the phone numbers and give you the corrected PowerPoint.
Yeah.
And then also, if you have any follow-up questions from this today, don't hesitate to contact Linda or me, and we'd be happy to take your question.
Yeah. And feel free to reach out to me as well if you have any ideas for trainings and, you know, just feedback and things like that. So again, thank you so much for everybody who is here today. And thank you to Bill and Linda. Take care and have a great rest of your afternoon and your week.
All right.
Thank
Thank
you.
you. Bye-bye.
Thank you.